My name is Joel Green. I am an attorney with AEGIS in their law practice group, primarily a transactional attorney. Do quite a bit of estate planning and real estate transactional work and general business representation. We're going to talk about the 10 myths about lawyers and common myths and the truths behind those myths. There are lots of myths out there, misconceptions, myths. So I just kind of put a couple of them together and just was going to take about 20 minutes or so and just kind of talk about them. But myth number one: attorneys are good businessmen and businesswomen. That is absolutely not always the case. It's obvious. I mean, lawyers are trained to be issue spotters and to be risk adverse. We're paid by our clients to keep them out of trouble. That means that by and large, we're pessimistic, we're cautious, and we get stuck in what I refer to as the analysis paralysis. And truth of the matter is, none of those are good business traits. So a lot of people will look at the education and the skill set and everything that goes into being an attorney and think that that's going to translate into either a good business person or worse, a good business partner. And that's oftentimes not the case. You're much better off taking the pros and the benefits of the legal acumen and the skill set, taking that information, but partnering with people that understand and appreciate your business, and using the legal and the attorney for the actual legal analysis and the issue spotting analysis. Attorneys are oftentimes considered to have very large egos, and oftentimes that's true, but an ego is never a good fit for a good business person either. Another common misconception is that all communication is confidential, and that's not ever the case. It's a bad practice to think that every communication you have with your attorney is going to somehow be protected or confidential. There is true that there is evidentiary privilege to communications and that there are ethical restrictions preventing attorneys from sharing freely the information. But it's actually a very rare circumstance where a communication with your attorney is absolutely privileged and cannot be uncovered. Generally, in order to even qualify as a privileged or a restricted communication, it needs to be within the scope of the representation. It needs to be directly tied to what it is that you're communicating and have hired the lawyer to represent you for. The information cannot be available from other sources, and you need to be aware that clients can sign and waive the privilege, and by using informed consent can make the decision to make that information public and disclosable, and that the court always will have the opportunity to compel a disclosure. Your attorney can find himself in a situation where they've got to communicate with the court and really go through some very heavy objections to keep that confidential. So as you're having your initial communications, understand that not all information is going to be protected. You want to make sure that you've got NDAs and everything signed with your attorneys at the time of the initial consultations, just to make sure that if it ever goes from the initial meeting and it doesn't go to a representation, you want to make sure that you've got yourself protected too. Another one is legal analysis will replace business judgment. This is something they actually teach you in year one of law school. You take a business associations class your first year of law school, and they hammer in the business judgment rule. That our role as attorneys is not to make business decisions. Our role is to analyze and address situations, issue spot, point out the pros and cons of any selected course of action, but the executive management of the business is actually who's charged. The board of directors and executive management is actually who's charged with making those decisions. Our role as an attorney is to advise, to look at, consider the facts, consider the precedents and the laws surrounding the facts, but ultimately is to advise the client on what the consequences of any course of action might be. You have to be able to say yes. And the answer is always yes. And the but is, yes, but here's the good side, and yes, but here's the bad side. But it has to be yes, because that is what the company's looking for, and that's what the startup's looking for. Can it be done? I mean, obviously it can be done. If you guys can imagine it, it can be done. But at what cost? Lawyers are expensive. And the answer is obviously. You work on some type of a compensation structure, whether it's the typical antiquated hourly basis, or if it's the industry trend where you're working on a flat fee type of alternative fee scenario. or whether it's on an equity basis. I mean, there are attorneys in the startup world that are taking equity in the companies in exchange for fees and taking fees in kind. All of those come with a cost. You know, the myth that lawyers are expensive is probably relatively accurate. But you need to look at what it is that you're paying for and what you're getting in return. But you know, there's about a 1,000-year-old adage that says an ounce of prevention is worth a pound of cure. And that could not be more true than in a legal setting. Whether it's an estate plan, whether it's a real estate transaction and you know, there was encroachments and easement issues, whether it's a startup where there's already an existing patent out there, you want to know those things from the front end, not on the back end. And it's going to cost you an awful lot less money. It's still expensive, but it's going to be an awful lot less expensive to find that out on the front end than on the back end. The client can stay informed, they can stay ahead of the curve. Our tax laws change every year, and you know, you need to have competent counsel that's out there looking and staying abreast of what those changes are and keeping you informed in advance so that you can make your business decisions on the front end rather than on the back end. You know, advanced counsel can keep clients out of trouble, or better yet, it can get them out of trouble when they get into trouble. So yeah, we're expensive, but at the end of the day, the question is it a reasonable expense? And I think when you actually look at the overall relationship, if you select, you know, an attorney that's going to be able to work with you on a proactive basis, you're going to find out that the advance cost is probably an awful lot less than paying to correct mistakes. All lawyers are created equal. The slide actually kind of speaks for itself. All lawyers are absolutely not created equal. Not only the very simple differentiators between a litigator and a transactional attorney, but you know, in today's world, I still actually kind of consider myself to be a transactional generalist. But there aren't a lot of them out there anymore, and frankly, that's not even a really great term for me, because I'm not going to do intellectual property. I will do some tax, but only in conjunction with a good CPA, and my preference, depending on the tax issue, would be to bring in a tax lawyer. The employee benefits and the ERISA, it's incredibly complex. So to have the skill set and the appreciation for the intricacies of statutory, you know, tax law and retirement account law, you know, and the financial savvy to be able to put all that together, that's a skill set. There's no way that you can compare an ERISA attorney with a family law attorney. No way that you can compare an ERISA attorney or a patent attorney with a, you know, just a general litigator. So there's absolutely no way to make a statement that all lawyers are equal. Lawyers are only in it for the money. You know, this is obviously a little bit more satirical, but it's a common misconception. And you know, there may be some truth to that. There might be a lot of attorneys out there, and there's probably are a lot of law students out there who have decided they're going to go into the profession because of what they see on TV and the expectations of big fat paychecks, you know, all the great quality of life and everything else. The truth of the matter is that most attorneys, certainly most new graduates, are not being well compensated. There are a lot of professions out there that will compensate you much higher than an attorney coming out of school. And when you adjust in for the billable hours and the amount of hours that you're actually working to generate that paycheck, your hourly rate becomes very small. And truthfully, there's an awful lot of attorneys out there who are going into it for reasons absolutely separate and apart from compensation. I just threw a couple up on the screen. We've got, you know, truly the pursuit of justice and the need and desire to help people. An awful lot of attorneys out there who that is their motivating factor. There are also an awful lot of attorneys out there who are just problem solvers. They like taking on an issue, figuring out a solution to it, and the legal environment is one that's very conducive to that. Here's the second time I use the word ego. There is a certain ego to being an attorney, and there are an awful lot of attorneys who pursue that simply because they have that ego element. And then the ability to argue or the desire to argue would be one that would lead people into the profession. But I don't think it's at all accurate to think that most attorneys, or even a lot of attorneys, end up staying in the profession long term because of the financial compensation. It might be what gets them into law school. A lot of times it might be, but beyond law school, I think it's a lot of the other more altruistic motivations. So myth number 7, a lot of people will come to us and think that lawyers are willing and able to make guarantees. That's absolutely not the case. And any lawyer that is making you a guarantee should be the last time you talk to that lawyer. It goes with our pessimistic nature. It goes with the fact that we're risk adverse. You can't make a guarantee. There's nothing in the legal profession that is black and white. And a good attorney would never make a guarantee, because we are trained to find the gray in everything. And in fact, that's part of the why you were hired by clients, is to help them navigate the loopholes, to find their way around situations that if it was a guarantee, that would mean it was black and white, and there would be no way around that. The attorney-client relationship is always very fact-specific. Our advice needs to be based on experience, and the results are always going to be based on precedent. But precedent, by its very nature, is changing. So precedent is guidance. It's guidance that the court's going to take, that the legislature's going to take, but it's not determinative. It's always going to be subject to discretion and interpretation, whether through the legislature, whether through the courts, or whether through some other governing body. And every representation needs to be based on quantitative and qualitative analysis. So in essence, you're looking for an all-encompassing approach to any fact pattern or any specific factual situation. There's no way to be able to make a guaranteed outcome, or make a guarantee of an outcome, when you realize all of that other input that has to go into it. Myth number 8, your lawyer should be obsessed with your case or matter as you are. I put that up there as a maybe, because there's actually some very good benefits to having an attorney that is as passionate as you are. And passion is very important, but it's not always a good thing. You don't want to just be operating with blinders. I don't want clients that are operating with blinders, but I certainly don't want clients to choose attorneys that are operating with blinders, because then you're both going blindly in what could be the wrong direction. And you need to have somebody with a rational look at it rather than just truly an emotional look. It's always good, at least until you've got yourself to a position with your counsel, to seek out, whether it's formally or informally, just kind of second opinions, just to make sure that you and your counsel are on the same page, and that we're moving in the right direction. A different standard for evaluation is a good thing. And you don't want an attorney that's going to be sitting there and just saying, there's no way he did it. There's no way he did it. Because you know what? There probably is a way, and you need to be thinking of that way, because I guarantee you the other side of the litigation has already thought of that way. So you need to make sure that you're covering all your bases and you're keeping all options open. The internet's a great resource for finding an attorney. So the answer is, it's got to be a maybe. Everybody's going to Google it, no matter whether it comes from a personal recommendation or a personal referral, friend or family. The first thing anybody's going to do is go Google it. So as an attorney, you need to make sure that your Google presence is positive, because that's the first place anybody's going to go. So it is a good starting point. Now, the value, in my opinion, the value of the internet starts and stops there at the starting point, because it can allow you to get some basic background information. It can allow you to kind of if you're acting completely independently and all on your own, it'll give you the opportunity to create a basic list of potential candidates. But it's imperative that you actually go out and ask around, get personal recommendation, personal referrals, do a personal interview, even if it costs you money, narrow down your list. But a lot of attorneys will give a free consultation, some won't. And it might be the ones that won't that you want to meet with. And you should budget in some time for those introductions if it's necessary. But you really want to get an idea of the applicable experience, not only from a general perspective that you can read on anybody's bio, but on a face-to-face type of meeting where you can get some personal accountability. Because every bio is just like any resume. It's tailored by that person to make that person look as great as they possibly can. And I have no doubt that most of those bios are absolutely accurate, and they've all done everything that they've said that they've done. But until you have the opportunity to actually meet with them and actually get personal recommendations from people who have worked with them, you should not limit it to that. This very easily could have been a maybe as well. And I didn't have enough room on the slide. I could have gone on and on and on and on. There are some bad apples, like there are in any trade or any industry. And by the nature of the beast. I mean, advocacy itself requires spin and manipulation. But I call it spin and manipulation because there are ethical ways to accomplish that spin and manipulation within the confines of whatever the issue is. That's always walking up to the gray area but never crossing over the line. Are there instances where attorneys have crossed those lines? Absolutely. And there are in any profession. We're trained to look for spot loopholes and to exercise our advocacy skills to have them be interpreted in a way that's beneficial to our client. Very easy to confuse that with lying. But I would say as long as they're doing it with the interest of fair dealing, they've got the truth and veracity, and ultimately at the end of the day, we have ethical obligations and we've got our reputation. We're going to run afoul of our ethical obligations because it's not hard to catch people in a lie, and unless you're wanting to be in that gray area, being found out to be a liar is going to hurt your professional reputation, and most attorneys are not going to go down that road. So that's it. That's number 10.